Welcome to Channel 17, the Town of Colonie Government Channel.
Hello, I'm Colonie Town Judge Peter Crummey, and welcome to Benchmark. We'll explore a variety of issues involving our justice system, our legal system, and how they intersect with the citizens of the town of Colonie. Today, we are truly fortunate to have as our guest Albany Law School professor Joan Stearns Johnsen. Professor Johnsen has distinguished herself in a variety of ways throughout her years of practice, and most recently, developing alternatives for dispute resolution. And Professor, thank you very much for joining us today.
Thank you so much for asking me.
As you know, the Colonie Justice Court is an exceedingly busy court with a variety of criminal and civil cases, and oftentimes the civil cases cause quite a backlog in the court system for people who are seeking some type of resolution to their problem or dispute, and the litigants often just really rely on the court to determine certain issues for them. But you and I both recognize there are a variety of other ways in which citizens can figure out their differences short of coming into the courthouse. And you've done such a fabulous job at developing those types of opportunities for people. And tell us what you're up to now at Albany Law School in this way.
Thank you so much, Judge Crummey. Well, what I'd like to do now is I'm trying to raise awareness of some of these alternative ways of resolving conflict. As you said, most people are just, when you get into a conflict with your neighbor or some sort of a small incident, maybe an automobile accident, what you want to do is you immediately see a lawyer and you want to file a lawsuit. What I'm interested in are there are other ways of resolving your conflicts regardless of the size or regardless of the nature. And one way in particular is a method called mediation. And this has been around for a number of years, and it's been growing in popularity. And it's something that I think people should be aware of. And what mediation is it's a negotiation where, you know, everybody knows about negotiation. You talk to somebody on the other side and you try and work out either a deal or you work out a conflict. And the concept of mediation is there's a neutral who's not on one side and not on the other and helps the party in a negotiation. And they can negotiate their way out of a conflict, or they can negotiate a deal, or whatever.
Well, Professor, you've distinguished yourself in this regard as a great settler of a variety of very large cases and disputes between groups, certainly in the commercial side, and spending much of your time also in handling commercial cases out of the city of New York, which is probably one of the largest commercial centers in the world. Here in the Colonie Court, too, I can see that court time is so very valuable, and having an opportunity for people to settle their differences outside of the courtroom is of great interest to the judiciary as well.
Right.
And I see that there are opportunities already that the court system has recognized its value and has promoted mediation first as a way to see whether it could short-circuit actual litigation. In fact, in our appellate division here in the 3rd Department, if there's an appeal pending from a Supreme Court decision, you first need to meet with a mediator before the appeal is considered by the appellate division. I see in our Albany County Family Court, for instance, that mediation is always offered to litigants as an opportunity to settle issues that may otherwise demand court attention. And we all know the dockets are overworked as it is.
Right.
And you've seen mediation required in certain instances, haven't you?
That's correct. last January 11th, the Southern District passed a rule that requires employment cases in particular to first go to mediation before they can be heard by the courts. So it serves a lot of purposes. As you point out, it can help the courts reduce their dockets. And it can be very satisfying for the parties, because mediation tends to really be about the parties and be an opportunity for the parties to express their differences and express their conflicts with one another, and have them be heard in a way that the courts really can't. The courts are fact finders. The courts apply the law. But in a mediation, it really is more about the parties, and the law can take a bit of a back seat. And the parties can find a result that serves their interests, whether or not it's actually what the law might impose on them.
That's right, and it does provide, it often can provide a less adversarial climate for people to work through the emotion that's often involved
Absolutely.
in a situation, the needs of both parties, Absolutely. And oftentimes it's a very costly effort to be in the courthouse.
Right.
I advise my own clients of that. It's time and money, and it's not as easy as just saying, let's just go to court.
Right.
I think that's the last thing that people who need a problem solved should be thinking. That's the last thing you should do.
I mean, it is a possibility, and we're not saying that you need to eliminate it.
Correct.
There are some times when you have to go to court.
That's right.
All we just want people to understand is it's not the only way of getting your conflicts resolved. And sometimes, as you point out, they can have their interests addressed, and you can even maintain a relationship. When you go to court, that should sort of be a last resort. I refer to it as nuclear war when you go to court. And it's very difficult at the end of that kind of a combative process to have a relationship. But when you go to mediation, you actually can maintain relationships. You can even reinforce relationships. And you can promote communication. Sometimes these conflicts arise because of misunderstandings, miscommunication. You think that somebody meant something, that their intentions were something, and maybe just bringing people together and sharing an apology. There's an instance where, this was a case that was in mediation. A friend of mine, it was a malpractice case, and a child died, a medical malpractice case. And the parties had been negotiating and trying to resolve the case directly, and they couldn't do it. And a lot of money was being offered to this family.
Sure.
And what happened was that when this child died, the lawyer instructed the doctor not to talk to the family. And when the mediator spoke to the family, the mother said, "This doctor delivered my last 2 children. And when my child died, he didn't call me." So when the doctor and the family got together, and there were apologies that were privileged, they couldn't be admitted,
Sure.
and there was crying, there were apologies, and then the case could be resolved.
Right.
And that served people's needs, treated people in a way that the court can't do. The court can resolve the case, but this is a way that another way of resolving the case. And it's important, it's not that the lawyers are not a part of it, because the lawyers play a very, very important role in mediation. Certain types of mediation. Now, it should be understood that mediation varies tremendously. As you said, I do a lot of commercial cases, and that's a specific style of mediation.
Sure.
As you said, that the courts will refer family cases to mediation. That's a very different style of mediation. But lawyers do play a very important role, especially in commercial cases. And it's a completely separate skill set that, that lawyers have. Lawyers don't just have to be advocates. Lawyers, as we've discussed, are problem solvers.
And they should be facilitators.
Right?
I agree.
Absolutely. So they have the skill set of going into battle and, you know, nuclear war if they have to, but they also have the skill set of negotiating and knowing how to represent a client in a mediation. So lawyers are no less valuable in a mediation. Commercial mediation, sometimes often in family cases, parties might not come with counsel present.
Right. But your point is well taken that the bar, attorneys, can welcome mediation for a case that they're involved in because it can help them get their client, who is their ultimate responsibility, to find justice in a format possibly outside the courthouse.
Absolutely.
Right.
Because as we know, sometimes when you win in court, you don't really win.
Right.
Sometimes nobody's happy. And the bar, absolutely. We're problem solvers as lawyers. Clients come to us, and it's up to us to resolve their conflicts. And yes, lawyers are very important in mediation as representatives of their clients. Absolutely, very much so.
So is there a difference? There's mediation, and
Yes.
then we've referred to, or have we discussed, mandatory mediation?
Well, mandatory mediation is misunderstood often because when courts refer you or require you to mediate, that doesn't mean that you have to settle. What that means is that you need to engage in the process. You need to engage in the process in good faith and try. But if at the end of the day, what you want to do is go to court, court is still available to you. But most cases, as we know, most cases settle before they get to court. And when you add mediation, even more cases settle. And the reason cases settle is because parties, it's in their best interest to resolve it themselves.
Right.
And
I agree.
as a judge, I'm sure you're more than
agree.
happy to impose solutions on people, but if people want to retain control over their solution, then they need to try an alternative method of getting their dispute resolved. And mediation is a very successful method that people find very satisfying and much more personal in a way than I think the court experience.
And the notion of mediation continues, thankfully, to continue to be accepted by our court systems as well.
Absolutely.
In that way. And even locally, there's a firm, Mediation Matters.
Absolutely.
And they'll oftentimes share one of their volunteers into my courtroom to assist in some small claims matters. And they'll take the time to conference with the litigants to see whether they could arrive at a settlement before I have to try the case and make a decision.
Right.
And not everybody wins when I make the decision as a result, and they know that going in. And you asked me previously, before we started today, as to how do you think that made the litigants feel when they settled with mediation? And I think that they were very happy with the way they did that, and they present themselves to the bench and both recognize that they've come to that conclusion, and I think they're both very happy about that decision.
And the parties get to participate.
Exactly.
And the parties can be creative in fashioning a resolution to their dispute, and they can have more input in it. And even the experience of being heard, of being able to talk to a mediator. And sometimes can be very satisfying when you get to court. And if you're represented by counsel, you answer questions. And it's not really about you, it's very much about the lawyers when you get to court. And in mediation, even when you're represented you have representation in mediation, it tends to be more about the parties. And Mediation Matters is wonderful. It's a wonderful organization. And there are a lot of community dispute resolution centers throughout New York. And Mediation Matters is a wonderful place. And that is a style. You mentioned that there are volunteer mediators, and they have a style of mediation.
Sure.
But people should understand that there are different styles of mediation, and that regardless of the type of conflict, there are different ways of mediating those conflicts. And people should also understand that that regardless of the conflict, like you can mediate a custody and visitation matter, and you can mediate a multicultural, multi-million-dollar, multi-party joint venture. Both mediation. The mediation process might look quite different.
Exactly.
So when people have a first experience with mediation, they might assume that that's what mediation looks like, and that's not necessarily the case either.
Exactly. And you started in the 90s. You got very much involved in the securities business in New York City when the notion of mediation was brought to the governance of that financial market. Is that correct?
That's correct. Actually, Ken Andrzejczyk, who is the director of the mediation program with what is now called FINRA, used to be the NASD regulation side. I introduced it to the securities industry, and it's really become part of the culture in that area. So that is another good illustration of different cultures. Now, these disputes, these are customer disputes within the securities industry, and it's about money, and sometimes quite a bit of money, and these cases are mediated. So you can contrast that, just as we were saying, with a custody and visitation dispute. Very different types of cases, both a great deal of success with having a third-party neutral help resolve the dispute.
In a nutshell, in the securities business, what would the typical disagreement be?
Oh dear.
Why would it need, it's a customer who believes that maybe something was done untoward to their particular account? Or, okay.
Yes, well, yes, in the securities industry, a lot of the customer cases, they would actually go to arbitration. They wouldn't be going to court. And yes, these would be cases that maybe you read about in the newspaper where a customer is concerned that they may not have, their account may not have been handled appropriately. Some of the claims that you hear about in the securities industry might be excessive trading, sometimes referred to as churning, unauthorized trading. Most cases tend to be what they refer to as suitability. Suitability is when you see your financial advisor, you should have a conversation with your financial advisor as to what your objectives and risk tolerance is. And then your financial advisor is required to make recommendations that are consistent with your risk tolerance and objectives, and if they fail to do that, then that would be unsuitable, what's in the account. And as I said, these cases would then go primarily to arbitration, but the vast majority of these cases are resolved prior to arbitration through mediation. So that would be most of the cases I would see. And in terms of mediation, there can be, these cases settle. Over 90% of these cases wind up being resolved. And that's in spite of the fact that one side walks in saying, I want millions of dollars. And this best case I've ever seen, the lawyer says, I'm going to retire. And on the other side, they may say, oh, no, this case, bad case, nuisance case. But when the parties come together and they realize, you might have that objective person doing a little bit of a risk analysis with both sides, and they realize, you know what? They really have they both have the same case, and they can figure out a way to resolve it without having someone tell them how to resolve it.
Professor, how long can a mediation, especially a New York City securities case, I mean, can it go on for a protracted period, or does the mediation process also take less time than litigation process?
As a general rule, boy, oh boy, does it take less time.
Right.
As a general rule, cases, in court, depending on the complexity of the case, the whole litigation process can take years.
Correct.
We're not just talking about the time you spend in court. We're talking about discovery and motion practice and appeals and everything, right?
Yeah, that's
Takes
correct.
years. Mediation, you can do in a day. Now, if you ask me how long does it take, the answer is it depends. The quickest case I ever had, case resolved in what's called joint session, opening statements, the parties started talking, case was resolved. The smartest thing I did was not say anything. And longest case, I'm a little bit of an ankle biter, and have followed cases for years. Until they've gotten their decision, I can keep after them.
Right, exactly.
So, but that's not the rule. I would say, a day.
Sure.
Some cases it's a few hours.
Exactly.
A couple hours.
And I'm glad you brought up the term arbitration, because there may be some of our viewers that wonder what the essential difference is between a mediation, which often suggests that it's permissive and that you're not bound by a decision of a mediator.
Right.
And how does that fit into arbitration?
Okay. Well, under the umbrella of alternative dispute resolution, which actually they're now referring to more as appropriate dispute resolution, because, sort of alternative to what? You have negotiation, which, people directly, you speak to one another and you resolve your dispute, party to party, lawyer to lawyer. Mediation, which is basically a facilitated negotiation, so you have a third party neutral in the middle. And then you go to arbitration, which is moving along the continuum closer to court. Arbitration is a contractual, it's not really court, but it's sort of more like court, because what you do is you hire arbitrators who are contractually hired. They're not judges, but they sit there and they all tell you who wins and who loses.
Right.
And there are witnesses, there's evidence, there's discovery to a greater or lesser degree, and then these arbitrators render a decision. Arbitration is much different from court. Arbitration varies from arbitration to arbitration depending on, it's a contractual relationship, so depending on the rules, and the parties at some level have control of the process. We can talk about that, how they have control, sometimes more or less, but it is a process that can be adjusted based on the conflict, based on the agreement of the parties. You may or may not have appeals. If the parties agree that there are no appeals, then you're done. So the arbitrators in the securities industry, arbitrators render a decision.
That's it.
Over and out.
Right.
No appeals. In arbitration in the securities industry, there tend not to be depositions. Right? So you go into a hearing, you haven't spoken to the other side. That's unusual for court.
Exactly.
In arbitration,
true.
The federal rules of evidence may not apply. So it may look different because of that.
So ultimately then, an arbitrator's decision is the final decision at that time, and a mediator's decision, it's not binding.
There's no
on the
decision.
parties. There's no decision at all.
Yeah, arbitrators have no power.
Right.
Don't tell anybody, because when I walk in there, but we really have no power.
Right.
And mediation is about party self-determination.
Sure. Yep.
So the mediator is there to facilitate. I'm there to test, to challenge, to question, to guide, to coach. But if you want to go to war, I'm going to wish you good luck, shake your hand, and...
Now, many times that judges have attorney conferences in chambers in order to facilitate a potential settlement of a matter.
Right.
And you cast that differently as to what a mediator does, because the climate's slightly different, right? It's
different. When parties come to you and they know that you're the person who's going to be deciding the case at the end of the day, the dynamic is different. Their ability to be candid with you, to share things with you, it's different. There are things that you might not find out throughout the course of a proceeding that might be influencing their decisions, and they may not want to disclose them to you when you're ultimately the trier of fact. But when I'm the mediator, things that I can do, and when I talked about different models of mediation, in some forms of mediation, the parties stay together the whole time, right? And the mediator's in the middle, and I'm, helping them communicate with one another, listening to one another. There's another model of mediation, which is called Caucus Space, which is used more frequently in a commercial context. So you take one party in one room, one party in the other room, and they'll tell me a lot of stuff that they don't want the other side to know. Right? But when you're their judge...
Right. And oftentimes, I don't have the parties in the room with the attorneys. So it's just attorneys with the judge, and that's it.
Right, so and when I'm mediating...
You see the parties, don't you?
It's very much about the parties.
Exactly.
And parties sometimes don't understand... Lawyers know what it's like to go to court.
You bet.
Parties don't understand exactly what it's like to go to court. Even between the lawyers and their parties. Like, I'll talk to a lawyer, I'll say, you got a good case? I got a great case. Really? What's the percentage chance you think you're going to win? Oh, this is a fabulous case. I think I got a 75% chance I'm going to win. What?
Right.
75%. I got a 60% chance I'm going to win. That's a good case.
Right.
Sure. Like, there's miscommunication. They don't understand. I got a 25% chance I'm going to lose. I got a 40% chance I'm going to lose.
Exactly.
Like, how much is it going to cost you to go the rest of the way?
Correct.
Oh, we're going to keep the costs way down. We got to get an expert. He's $10,000.
Right.
We've got to do this. It's another $2,000 or $3,000. It's going to cost how much? Right? It's going to take how many days? How much time out of the office?
Professor, our students at Albany Law School have benefited by your instructing them on a variety of different topics. One topic I'm interested in right now is the course that you teach in negotiating for lawyers. What do you tell our law students about negotiating? What do you tell them?
It's, it's fascinating. It's a complete paradigm shift in the way we teach negotiation.
Right.
A lot of people, when they approach negotiation, they don't really think about what they're going to do. They don't really think about preparing. They kind of figure, you know what? When I get there, I'll see what he does, and then I'll respond to it. But what science is showing us is that psychologically, there are factors that influence our decision-making that maybe might influence the way that we negotiate, that maybe taking those advocacy skills from litigation into a negotiation may not be the most effective way of getting the best deal. That sometimes when we go into a negotiation, we think about what we need. How am I going to get what I need? How am I going to get what my client needs? And it's surprising, but sometimes the best way to get what your client needs is to figure out what the other guy needs.
Exactly.
Because you're never going to get a deal if you're not serving what the other guy needs. And the other thing that we're finding out is that when they talk about, some of the terminology I think is problematic, because they talk about win-win, or they talk about interest-based or problem-solving, and you might assume that that means, oh, I gotta fold, I gotta be weak, I gotta give up, and that's not what it means. What it means is, if I can serve your interests, it may not cost me anything. And that's how we both win. The story about integrative negotiation that it really illustrates it. I don't know how much, do I have a minute? Integrative negotiation is, there's a mom, right? 2 daughters. Daughters show up to mom, they have 1 orange left. They both want the orange. What does mom do? What do you think, mom?
Split it.
Split it, right? You cut, you pick. No. If mom inquired, that's what you
That's
think.
right.
Right?
You cut, you pick.
Right?
Yes.
But if you inquire into, when I said you have to serve the interests of the person on the other side, if mom took the time to talk to the two daughters and find out, what do you want the orange for? And the one daughter says, well, I'm hungry, I want to eat the fruit. The other daughter says, I'm baking. I want the zest for my spice cake.
Mm-hmm.
You know, cut the orange in half. One can have the zest, the other can have the fruit. That's an integrative solution. Those situations are far more common than people realize. But you never find those out when you take the advocacy skills that you know from trial court into your negotiations.
Well, Professor, it's certainly been our great pleasure to have you here today on behalf of the citizens of the town of Colonie, and now all of us know that our Albany Law School and our students there with you have both the zest and the fruit. And thank you for joining us here today, Professor, and we look forward to having you again very soon.
Judge Crummey, thank you so much for inviting me. It was a pleasure.
I'm Judge Peter Crummey, and thank you for joining me on Benchmark.